Labor Day and Labor and Constitutions. Tuesday, August 30th, 2022, 9 a.m. Labor Day is a bittersweet holiday. Jovial because of the liberty associated with the long weekend. Disparate because it denotes the unofficial end of summer. For some parts of the United States, it means little difference in temperatures. For others, it means the beginning of cooler days coupled with heavier clothing and, yes, the famous pumpkin spice latte. The U.S. Supreme Court has three interesting cases that have some connection to Labor Day in the United States. One, a case concerning a petitioner whose speech at a gathering on the holiday served as evidence of her part in a conspiracy against a judge. Two, a joint Labor Day committee was among the recipients who received dues, donations, and subscriptions. And three, the American Civil Liberties Union wrote a letter to a woman who was sterilized against her will, asking her to call collect by the Friday before the holiday weekend. Besides the typical list of holiday discussions at the court, see my Memorial Day mentions at the U.S. Supreme Court from May 30th, 2022, and marking your Independence Day from July 3rd, 2022. These comprise the extent of the mentions for Labor Day at the U.S. Supreme Court. Perhaps because the U.S. Constitution once mentioned labor in the context of regulation of slavery, a provision that has since been nullified with the introduction of the 13th Amendment. Other constitutions of the world spend a considerable amount of time on labor matters, such as forced labor, the right to labor, and policy, legislation, courts, and agencies that are specially designed to attend to labor. Types of laborers and forced labor. While the U.S. Constitution gives scanty review of labor, labor has more specifically constitutional regulation in other nations. Starting from definitions of types of laborers, many forms exist throughout constitutions, such as agricultural laborers, child laborers, forced laborers, free bonded laborers, and in general, laborers. Further, like the United States, slavery is abolished, but these constitutions go so far as to say that forced labor is not permissible. This made way for many constitutional exceptions in several specified cases. 1, during states of emergency. 2, when individuals are lawfully detained. 3, when part of a court sentence. 4, when working in capacity for a state or military position or other civic obligation. And 5, when in the interest of hygiene. Some of the forced labor provisions are included among texts that prohibit inhumane or humiliating conduct or punishment, traffic in human beings, and the most oft written about child labor. For the last, the age is either prescribed by law or constitutionally mandated. Sometimes children are constitutionally guaranteed the right to equal pay for equal work, while other times special measures are implemented to protect young people. Related to the prohibition against forced labor is the concept of the right to withhold or withdraw labor without criminal penalty. Right to labor. Many nations take it further by asserting that there is a right to labor itself. Also, the right to fair and equal remuneration is a prevalent constitutional theme. Sometimes the right to labor is further deepened by establishing a right to trade unions. Italy's Article 39 is an interesting example in that the only obligations placed upon unions are that they be registered, that the trade unions be democratically comprised, and that they become legal persons. Hungary's Article 17 considers cooperation between employers and workers, collective agreement making, working conditions that are healthy, safe, and dignified, and rest periods and paid leave. Sometimes the allusion to trade unions is definitive, such as in Malaysia, where the Constitution establishes a freedom to form associations related to labor. Policy, legislation, courts, and other organizations pertaining to labor. Labor is also presented in constitutions concerning policy, legislation, and specialty courts and organizations. Many nations have constitutional provisions pertaining to labor policies. These policies promote sound labor relations and fair employment practices such as addressing workforce competence and professionalism, ensuring the basic rights of all labor, abolishing exploitation, encouraging good relations between the workforce and management, and protecting foreign employment. Labor is constitutionally tied into economic markets. Sometimes responsibilities are specifically enumerated, like decision-making of management and professionals, or vocational training and advancement of workers. The policies may be based upon valuable work and free enterprise as well as fair economic competition. Some of the labor policies are rights-centered, such as labor defamation and freedom of movement for labor. These policies are implemented by a variety of organizations, exemplified by a National Inclusion Commission that studies labor in Nepal, a council of ministers to direct labor and social security in Mozambique, a National Council for Economics and Labor as a constitutive body for the houses and government of Italy, and as translated, a President's Commission to investigate the conditions of the quote-unquote backward classes, to include investigations into the difficulties under which they labor in India. Labor has also had a presence in constitutions addressing international matters, where it has been mandated that a nation maintain membership in international organizations. Many types of legislative responsibilities relate to labor. The topics of legislation include labor organizations, regulation of labor and safety in mines and oil fields, labor and social security, welfare of labor, including housing by employers, employer liability and workers' compensation, and human rights such as slavery, servitude, or forced labor. Some constitutions delegate legislative authority for labor at the state level. Specialty courts have been constitutionally established for this topic. These courts have been called industrial relations courts or national industry courts, amongst others. Structurally, they can be expressly subordinate to the High Court. Further, they have original jurisdiction over labor disputes and other related issues like labor, employment, trade unions, industrial relations, and matters arising from the workplace at the national and sometimes international levels. When celebrating Labor Day 2022, know that the legacy of the American Constitution and its subsequent amendments, especially the 13th Amendment, are present in the constitutions of other nations.